Chapter 1. The Methods of Constructing the Concrete in the Abstract Sciences. In the study of its subject, every science which makes generalizations is dealing with one and the same concrete and total reality, one and the same observation, such as the observation of a heavenly body moving through the meridian, can give rise to psychological as well as astronomical inferences. One and the same facts, such as the leasing of land, can form the subject of juridical as well as economic investigations. Thus, the various sciences differ mainly in their approach to reality and in their methods. Each science has its own particular Each science has its own particular design, in terms of which it attempts to reproduce reality. In so doing, each science constructs concrete reality in all its wealth of forms, internal relations, and dependencies as the result of a combination of the most simple abstractions. Psychology tries to break down consciousness into its most simple elements. Chemistry applies the same approach to matter. Wherever we are unable in practice to break reality down into reality's most simple elements, abstraction comes to our aid. Abstraction has a particularly large role to play in the social sciences. The maturity of a social science is determined by the degree of perfection attained in the relevant abstraction. Marx illustrates this in an impressive manner with reference to political economy. Marx maintains that it would seem quite natural to begin one's analysis with the concrete totality, with the population living and producing in a particular geographical environment. But that population is an empty abstraction if one leaves out the classes of which that population is composed. These classes, in turn, mean nothing without the conditions of those classes' existence, such as wages, profit, rent, and so forth. The analysis of the latter presupposes the elementary categories of, quote, price, quote, value, and, quote, commodity. Taking these simplest determinants as his starting point, the economist reproduces the same concrete totality, not any longer, however, as a chaotic blurred whole, but as a, quote, rich totality of many determinations and relations, end quote. Marx adds, moreover, that the historical development of economic science has followed precisely the opposite course. The economists of the 17th century started from the concrete nation-state population in order to deduce rent, profit, wages, price, and value. Yet the fact that it was historically unavoidable to proceed in this manner does not make it methodologically correct. These observations are directly pertinent to the general theory of law. The concrete totality, society, the population, the state, must in this case, too, be the conclusion and end result of our deliberations, but not their starting point. By moving from the most simple to the more complex, from the process in its purest form to the process's more concrete manifestations, one is following a course which is methodologically more precise and clearer, and thus more correct, than if one were to feel one's way forward, with nothing more in mind than a hazy and unarticulated picture of the concrete whole. The second methodological observation, which it is necessary to make sure at this point, concerns something which is specific to the social sciences, or rather to the concepts used by the social sciences. Take, for example, some concept from the natural sciences, such as energy. We can, of course, establish the exact point in time when it first occurred. Nevertheless, Such a date means something only to the history of science and culture. In scientific research itself, the application of this concept is not at all predicated on any time limits. The law of the transformation of energy was in effect before man appeared on Earth, and it will continue to take effect after all life on Earth is extinct. It exists outside of time. It is an eternal law. One can indeed ask when the law of the transformation of energy was discovered, but it would be futile to raise the question of when the relations which the transformation of energy, the law of the One can indeed ask when the law of the transformation of energy was discovered, but it would be futile to raise the question of when the relations which it expresses date from. Turning now to the social sciences, to political economy, for instance, and considering one of its fundamental concepts, such as value, it is immediately obvious that this concept, value, not only has an intellectual history, but that associated with the history of this concept, as part of the history of economic theory, is a real history of value as well, a development in social relations which has gradually turned the concept into historical reality. We know exactly which material conditions are necessary for this, quote, hypothetical, quote, imaginary quality of things to gain a, quote, real, and indeed decisive significance as compared with their natural properties, transforming the product of labor from a natural into a social phenomenon. Thus we are familiar with the real historical substratum of those cognitive abstractions we use, and we can at the same time satisfy ourselves that the limits within which the application of these abstractions is meaningful are synonymous with, and are determined by, the framework of actual historical development. Another example cited by Marx illustrates this particularly graphically. Labor as the simplest relation of man to nature is present at all stages of development without exception, yet as an economic abstraction, labor is relatively recent. Compare the sequence of schools of thought, the mercantilists, the physiocrats, the classical economists. This development of the concept of labor was paralleled by the actual development of economic relations, a development which pushed aside the diversity of human labor, replacing the diversity of human labor with, quote, labor in general, end quote. Thus, the development of the concepts correspond to the actual dialectic of the historical process. Let us consider another example, this time not from the field of political economy. Take the state. Here we can observe how, on the one hand, the concept of the state gradually acquires precision and definitiveness, and develops the full potential of its determinants, and yet, on the other hand, how the state in reality grows out of the gens community and feudal society, quote, abstracts itself, end quote, and transforms itself into a, quote, self-sufficient, end quote, force, quote, blocking up all the pores of society, end quote. Hence the law in its general definitions, law as a form, does not exist in the heads and theories of learned jurists. Law has a parallel real history which unfolds not as a set of ideas, but as a specific set of relations which men enter into, not by conscious choice, but because the relations of production compel them to do so. Man becomes a legal subject by virtue of the same necessity, which transforms the product of nature into a commodity, complete with the enigmatic property of value. To the kind of thinking which does not transcend the framework of the bourgeois conditions of existence, this necessity must appear as none other than natural necessity. That is why all bourgeois theories of law are based consciously or unconsciously on the doctrine of natural law. The school of natural law was not only the most marked expression of bourgeois ideology, at the time when the bourgeoisie acted as a revolutionary class, formulated its demands openly and consistently. The school of natural law also provided the model for the deepest and clearest understanding of the legal form. It is not by chance that the period when the doctrine of natural law flourished coincides approximately with the appearance of the great classical bourgeois political economists. Both schools set themselves the task of formulating, in the most general and consequently the most abstract manner, the fundamental conditions of existence of bourgeois society, which they regard as the natural conditions of existence for absolutely any society. Even someone so overzealous in the cause of legal positivism and so opposed to natural law as Bergbaum feels bound to acknowledge the achievements of the natural law school in laying the foundations of the modern legal system. Quote, natural law threatened serfdom and bondage, and pressed for an end to people's enslavement to the land and soil. The natural law school unleashed the productive forces which had Natural law unleashed the productive forces which had been fettered by the coercion of an ossified system of guilds and by absurd trade restrictions. It achieved freedom of religious persuasion as well as the freedom of scientific teaching. It gained the protection of private law for every religion and every nationality. It helped to abolish torture and to guide the criminal case into the ordered course of a procedure according to law. End quote. Bergbaum. Karl Bergbaum. Mantis toboggan. While not entertaining the intention of concerning ourselves in full detail with the sequence of the various schools in the theory of law, nevertheless we cannot avoid drawing attention to a certain parallel in the development of juridical and economic thought. Thus the historical tendency can be considered in both cases as a manifestation of the feudal aristocratic and in part of the petty bourgeois guild reaction. Further, when in the second half of the 19th century the revolutionary zeal of the bourgeoisie finally faded out, the purity and precision of the classical doctrines simultaneously lost all attraction for the bourgeoisie. Bourgeois society yearns for stabilization and a strong-arm. That explains why it is no longer the analysis of the legal form, but the problem of justifying the binding force of legal regulations, which becomes the focal point of interest for juridical theory. The result is a strange mixture of historicism and juridical positivism, which is reduced to negating every law except the official law. The so-called, quote, Renaissance, I think it's not spelled that way, it says Renaissance, but I think it means Renaissance. The so-called, quote, Renaissance of natural law, end quote, does not signify that bourgeois legal philosophy is reverting to the revolutionary views of the 1700s. In Voltaire's and Beccaria's time, every enlightened judge counted it as an achievement if, in the guise of applying the law, he succeeded in substantiating the ideas of the philosophers, ideas which were no less than a revolutionary negation of the feudal social order. In the present day, the prophet of Renaissance, quote, natural law, end quote, Rudolf Stammler, advances the thesis that, quote, true law, end quote, richtiges Recht, requires first and foremost subjection to positively promulgated law, even if it be, quote, unjust, end quote. A parallel can be drawn between the psychological school of jurisprudence and the psychological school of political economy. Both are at pains to transfer the object of analysis into the realm of subjective areas of consciousness, quote, evaluation, end quote, quote, imperative attributive emotion, end quote, and fail to see that the ordering of the corresponding abstract categories expresses the logical structure of social relations which are concealed behind individuals and which transcend the bounds of individual consciousness. Finally, there is no doubt but that the extreme formalism of the normative school, Kelsen, expressed the general decadence of the most recent bourgeois thinking, which spends itself in sterile methodological and formal logical humbug and parades its own complete dissociation from actual reality. In economic theory, the representatives of the mathematical school would fill the corresponding position. The legal relation is, to use Marx's expression, an abstract one-sided relation, which is one-sided not as a result of the intellectual labor of a reflective subject, but as the product of social development. Quote, in the succession of economic categories, as in any other historical social science, it must not be forgotten that their subject, here modern bourgeois society, is always what is given, in the head as well as in reality, and that these categories therefore express the form of being, the characteristics of existence, and often only individual sides of this specific society, this subject, end quote. Marx, Grundrisse. What Marx says here about economic categories is directly applicable to juridical categories as well. In their apparent universality, they in fact express a particular aspect of a specific historical subject, bourgeois commodity-producing society. In conclusion, we find in the same, quote, introduction, end quote, by Marx, from which we have already quoted so freely, yet another profound methodological observation. This methodological observation concerns the plausibility of clarifying the significance of earlier structures through the analysis of later structures, and consequently more highly developed structures. If we understand ground rent, Marx says, we can also understand tribute, tithes, and feudal dues. The more highly developed form renders the prior stages, in which it appears only as an embryo, comprehensible to us. The later evolution simultaneously reveals the intimations implicit in the distant past. Quote, bourgeois society is the most developed and most complex historic organization of production. The categories which express bourgeois society's relations, the comprehension of bourgeois society's structure, thereby also allows insights into the structure and relations of production of all the vanished social formations out of whose ruins and elements it built itself up, whose partly still unconquered remnants are carried along with it, whose mere nuances have developed explicit significance within it, etc. End quote. Marx. Applying these methodological considerations to the theory of law, we must start with an analysis of the legal form in the legal form's most abstract and pure shape, and then work towards the historically concrete by making things more complex. In the process, we must not lose sight of the fact that the dialectical development of the concepts parallels the dialectic of the historical process itself. Historical development is accompanied not only by a transformation of the content of legal norms and legal institutions, but also by development in the legal form as such. Having emerged as a particular stage of culture, the legal form persists for a long time in an embryonic state, with minimal internal differentiation, and with no clear demarcation from neighboring spheres, Moore's religion. Only after a period of gradual development, does the legal form reach its full flowering, its maximum differentiation and definition. This highest stage of development corresponds to quite specific economic and social relations. This highest stage of development is characterized simultaneously by the emergence of a set of general concepts which comprise a theoretical reflection of the legal system as a perfected whole. Corresponding to these two cycles of cultural development, there are two epochs when the general concept of law reached their highest point of development. Rome, with its system of private law, and the 17th and 18th centuries in Europe, during which time philosophical thought discovered the universal significance of the legal form as a possibility which bourgeois society was destined to embody. It follows that we can reach clear and exhaustive definitions only by basing our analysis on the fully developed legal form, which recognizes itself in embryo and preceding legal forms. Only then shall we comprehend law not as an appendage of human society in the abstract, but as a historical category corresponding to a particular social environment based on the conflict of private interests.